Chris Dutton is a senior associate in the Porter Rights Litigation Department, focusing on construction and commercial business litigation. Chris has been involved in the successful resolution of claims in the state and federal courts in both Ohio and Kentucky, as well as multiple private arbitrations and mediations. Chris also has a pre-law background that is rooted in the construction industry. So this kind of gives him a leg up when it comes to issues that contractors like you are facing. So without further ado, I will turn the floor over to you.
Oh, thank you, Jen. You're my favorite. Hi, guys. Yeah, this is Chris. Like Jen said, I have my undergrad is in construction. I was a project manager, estimator before I did the whole law school thing. And I know you hear a lot of attorneys and accountants and insurance folks telling you things, and you think to yourself, they don't understand. They don't know what I'm dealing with. I like to think that I do. So I'm happy to be here. I'm happy to be talking to somebody who aren't my kids right now. So thank you for attending. And I'd like to make this as much of a dialogue as possible. And this is my first webinar ever. Even before this current situation, there were webinars. I had never done one. So I've never done a webinar before. And if I screw this up, I'm very sorry. But I'm gonna try hard not to. But I would like as much interaction from you all as possible, because the last person on this experience here that wants to hear me talk for 2 hours is me. So if you all have questions, if you have comments, if you have war stories, and you have the ability to chime in and ask them or talk about them, I welcome it, okay? So I'm going to smash the share screen button here and hope that it works. Can y'all see that? We good? Can everybody see the screen over here? Contracts, sophisticated overview?
Yeah, I can see.
You can see that? Cool. All right. Well, we're going to begin our sophisticated discussion of contracts with revisiting The Little Mermaid. Y'all have seen this movie, I presume. And when I was a construction management student at UC, we had a construction lawyer who reminds me a lot of myself now, come in and talk to our class about construction things and construction contracts. And I don't even remember what particular provision he was talking about, but he read off some contract language and he said something to the tune of, "This means nothing to me. It's unenforceable. I'll plow right through that." And I thought, wow, that's bold. It's there in this contract. It's in black and white, and everybody signed it. Everyone's bound to it, right? That's just the deal you made. Now you have to live with it. It's kind of the Little Mermaid perspective on contracts. If you've seen the movie, you know what I'm talking about, and if you haven't, I'll bring you up to speed. Basically, the Little Mermaid, Ariel, made a deal with the Sea Witch, and she said that she would basically sell her soul to the devil in exchange for the opportunity to have a 3-day shot at true love. And she signed the deal, and her true love in Disney terms is basically a kiss, because that's true love. You kiss somebody, you're in love. So she had 3 days to kiss her true love or else. And she signed this deal, this document, and didn't happen. For better or worse, she didn't get her true love in 3 days, and the sun went down, and the Sea Witch came to collect. And her father was King Triton. King Triton was basically Jehovah, Muhammad, whatever religion you practice, he was the Messiah of that one. And he shot the contract with his magic trident, and he couldn't break it because it was a contract, and you can't break a good contract. I think that's the perspective that a lot of people have of contracts, that if it's written down, it is what it is, you can't undo it, and you're bound by it. To some extent, that is true, but not completely. It's not the type of thing that God himself or herself can't undo. In The Little Mermaid's situation, there are a ton of defenses under the American jurisdiction that she could have enacted. She was a minor. The sea witch interfered. I mean, there are lots of defenses to the contract in The Little Mermaid. And the first thing that I want to say to you here, we're talking about contracts, is your contract is basically the price of admission. It's something for you to argue about. It's something for you to talk about. Without it, you're pretty well doomed. To argue something that isn't captured in a contract is a very difficult situation. But the fact that you have a contract is great, but it's not the end of the day. And we're going to talk about some of the things that make it better, and some of the things that aren't so good about contracts. Does anybody have any questions so far? Is everybody there? Who's on the phone? Can everybody speak up real quick just so we can get some interaction here? What we got? Okay. Maybe everybody's muted. I don't know, but we'll keep going here. And if anybody needs anything, if you can, let me know. So the first thing we want to talk about is what's in your contract, or what is a contract is a better question. There are 3 or 4, depending on how you slice it, things that make a contract, okay? Offer and acceptance are the 2 obvious ones. In order for there to be a contract, somebody has to offer to do something for whatever price or whatever thing that they're going to do, and somebody else has to accept it. I'm going to build your building for X money. I'm going to design your building for X money. I'm going to walk your dog for X money. It's an offer. This is a thing. I am willing to do this, and these are my terms. And then somebody has to accept it. That's the second one. It's pretty obvious. Okay, I understand your offer. I get it. And that sounds like a good deal to me. I accept. So offer and acceptance are pretty fundamental. They're easy to understand. The third and /4 are a little bit more complicated. Consideration and legal detriment. They're kind of the 2 sides of the same coin, which is why I call them both 3 and 4, because they're kind of the same thing, which makes them only one, but they're kind of separate. So consideration and legal detriment, basically both sides have to be giving up something, okay? If there is a contract, it can't be just a promise. I promise you that I'll give you $100. That's not a contract, that's a promise. You know, nobody, the person who is promised $100 hasn't given up anything. They've only been guaranteed in a promise sort of way that they're going to get $100. A contract requires consideration and legal detriment. I'm going to give you something, you're going to give me something. We're both going to exchange value. If you don't have that exchange of value, it's not a contract. Sometimes you'll see those goofy real estate contracts that say, I'm going to sell you $1 million worth of land for $1, $1. The reason that $1 is in there isn't to be cute. It's because it's consideration. It's something of value. It doesn't have to be equal. It just has to be there. And in order for there to be a contract, offer, acceptance, consideration. And why does this matter to you? Change orders. Change orders is a big deal. If you have a change order, you might say, for example, to give you a scenario here, I have a contract to build your house. I'm going to pay you $100,000 and you're going to build me my house. $100,000 for my house. You come back to me a couple months in and say, I can't do it. I can't get it done for $100,000. I need $150,000. A contract is a binding thing. You're stuck with it. Once you sign it, once you own up to it, it's yours. Okay? So we come back to this $150,000 proposal and I say, why? We already have a contract for $100,000. You say, I can't do it for $100,000. It's got to be $150,000. You don't give me $150,000, I'm walking off your job. And I say, fine. I need my house. I need it done. You know, I planned on this. I'm concerned about it. Fine, I'll pay you $150,000, even though we have a contract for $100,000. So we move forward. You finish my house. You send me your invoice for $150,000. I say, our contract's for $100,000. Here's $100,000. I'm not paying you $150,000. We had a deal. You sue me, you lose, because there was no consideration. for the extra 150,000, or I'm sorry, for the extra $50,000. We had a deal for 100. That's binding. You came back to me and said you need 150. I said, sure, I'll pay you an extra 50, but I didn't get anything for it. I already had a deal with you to do it for what you said it was. There was no consideration for that extra $50,000. You didn't give me anything else at all. And that's a promise. That's not a contract. So when you're signing your change orders, it doesn't have to be equal. It doesn't have, whatever you gave me doesn't have to be worth $50,000. Say I'll upgrade your floors from vinyl to carpet or whatever, you know, just give me something else. But consideration is the big one. That's where the lawyers like me make their money. It's the hard one. Offer and acceptance are easy. So remember that, consider that. And change orders are contracts, or at least amendments to contracts. So get something for it. They don't call it breach of promise. There is such a thing as breach of promise, but it's not a good argument. If you're arguing breach of promise, it's called promissory estoppel in lawyer words. It's a tough row to hoe. You don't want to be in that position. So make sure your contracts are up to speed, and mirror image. You want to make sure your offer and acceptance match each other materially. Okay. If I say to you, I need you to build my house for $100,000 in 6 months, and you reply, okay, I'll build your house for $100,000, but I need 8 months. That's not a mirror image. That's a material difference. 6 months to 8 months is different. That's not an acceptance at all. What that is a rejection and a counteroffer. So if somebody offers you to do something and you mark it up and change all of it, that's fine. That's negotiation. That's business. I get it. But that is not you accepting their offer. That is you sending them a counteroffer, which is something different. So in that, with that context, we want to talk about what's in your contract. Now, a lot of folks think about their contract as just, you know, that very obvious document that's got, you know, the 2 pages fully, or 2 columns rather per page, fully justified. It's got numbered clauses. It's got a lot of heavy words in it, like notwithstanding and heretofore. That's your front end contract. That's where you start. That's your that's the engine of the choo-choo train, but it's not the end of it. There are lots of other things in your contract. For example, apologize here, you might have general conditions. Most often you will have general conditions in your contract. The AIA documents have the A201, which most of you all are probably familiar with. If most construction, like the front end contract is a relatively short document. It might be 10 or 12 pages, and it doesn't have a lot of information in it. It has some information in it, but there will be a part of your contract that talks about the other stuff that is also part of your contract, and it will incorporate things like the A201, which is the general conditions, which is a much longer and more involved document, and it has all of the stuff that we're talking about in it. We'll get to that in a second here. But your contract types, the AIA, maybe you all are seeing something different in the construction world. I'm obviously an attorney. I only see broken construction projects. For the most part, I usually either see an AIA document, AIA standing obviously for the American Institute of Architects, or some uniquely crafted document by a company. So the AIA, they came out with a publication of documents. They have a contract template for every type of situation you can think of in construction. I think there are literally over 100. No matter what you need a contract for, the AIA has your answer. And I think they did it first, and because they did it first, they have the most sourced template out there. More often than not, if I'm looking at a construction contract, it's an AIA contract. If I'm not looking at an AIA contract, I'm usually looking at something that some company or some company's lawyer drafted specifically for that. There are other templates available. Consensus docs, for example. Consensus docs came to us because obviously being prepared by the AIA, the American Institute for Architects, the AIA documents tend to be architect friendly, tend to be a little owner friendly. And the consensus docs was an intentional effort to make a more balanced, more contractor friendly approach. They haven't got the traction yet that AIA has, but they're newer, so it may take some time. On public projects, public entities, the federal government is a great example. They kind of do their own thing. They have their own document. And some of you might have seen it, but if you do OFCC work, the Ohio Facilities Construction Commission, they've got a document too. The point of this slide and the point of this part of the talk is your contract is broader than what you see when you're looking just at that legal looking document in front of you. It's going to incorporate a bunch of other things. For example, the drawings and the schedule. It is pretty common for a construction, and it's not common, it's almost always the case on a commercial construction project. It's usually towards the end, there'll be a clause that says contract documents, and it will say, these are the things that are in my contract. Aside from this document that I'm reading right now, here's what else. It almost always says plans, specifications, schedule. Sometimes it'll say geotechnical report. It will say safety procedures, insurance requirements. There's all kinds of things that can be attached to a contract, and when they are attached, when they are incorporated by reference, we've got a slide coming for that, they are part of your contract. So if for whatever reason your contract doesn't include the plans, then if you don't build according to plans, then maybe you're not in breach of contract, but they are going to be in there. The plans are going to be part of your contract. And when you don't build according to plan, when you don't build according to schedule, when you don't observe the safety requirements that are part of your contract, you're in breach, potentially. So that's the argument. So the first thing and the most important thing when you're getting into a deal is to make sure you have gathered all of the contract documents, not just that 30-page thing, 12-page thing, however long it is in front of you, and reviewed them all to make sure you're comfortable with it. I have had a lot of clients along the years that had no idea what they had bound themselves to when they signed on the dotted line at the end of that 12-page document because they hadn't looked at all the things that were incorporated in it. Flow down provisions. This is another big one. During my construction days, before I became a lawyer, I worked for a drywall company, commercial drywall company. We were pretty big at the time. We did commercial projects, and I didn't get the biggest projects because I was young and inexperienced, but I still got some pretty good projects, and I negotiated my little contracts, and I estimated them, and I never appreciated the flow down provision. Basically, what a flow down provision does for the subcontractors on the call here, and even the contractors, flow down provision basically says, here's everything that my contract, my subcontract with you says. This is what we're going to do. But there's this other contract out there, looming large. The general contract. It's the contract between me as a general contractor and the owner. And I've got a lot of responsibilities to this owner, and I'm passing them all on to you. So basically, we've got this contract between us that requires all these obligations between us, but I'm also going to require you to respect me contractually the way I have to respect the owner. All of these things in this general contract now are in your subcontract. And you replace the term owner with general contractor, and you replace the term contractor with subcontractor. You owe me all of the duties that I owe the owner. That's heavy. That's a big deal. And I signed a lot of contracts back in the day with flow down provisions in them, I suspect. I don't know, because I don't know if I was fancy enough to respect them at the time, but your average commercial contract has a flow down clause. Your average commercial subcontract rather has a flow down provision in it, and you're signing on to every obligation that you can read and all the obligations that the contractor owes the owner. And it is pretty common for the subcontractor to never actually see the general contract. And that's a problem sometimes. Now, the general contractor may not want to share with the subcontractors, for example, the amount they're getting paid, what the price of their contract is. That's fine. You can black that out. We call it redacting as lawyers. You redact things that the subcontractor has no business knowing about. But if you're a subcontractor and you're signing a contract that includes a flow down provision, you need to see that general contract. You don't know what you're signing up for. There might be a liquidated damages clause in that general contract that's not in your contract. So I got a subcontract, it's silent. Doesn't say anything in the world about liquidated damages, but it's got a flow down provision that says I'm binding myself to this deal, to the same deal that the general has with the owner. And that deal has a $2,000 per day liquidated damages clause in it. That might become your problem if this project goes south. You want to know that. You want to know that. You want to see that. And it's not inappropriate for you to ask for it. I understand that it's awkward for a subcontractor to say, hey, general contractor, I've got this flow down clause. I'm obligating myself to things that I've never even seen before. I need to see your contract. I understand that it's difficult sometimes for a subcontractor to say I need to see your contract with the owner. Do it anyway, because you need to know. You need to know what you're binding yourself to. And if a general contractor gets odd about it, just say, hey, if there's anything in there you don't want me to see, redact it. And to the general contractors on the call, same thing. You want your subs to know what they're getting into. You want them to fully understand what's involved here and protect your confidential information for sure. I said they don't need to see what your price is with the owner, but they do need to see the terms of the deal. And too many times, it's just not disclosed. So make sure everybody is fully aware of the deal they're getting into and involved in it. Incorporation by reference, that's what I was talking about here earlier. That's that last page clause that has all of the things that might be part of your contract. Incorporation by reference is the part that brings everything in. It's enforceable, it is binding. Don't make assumptions. You know what they say about assumptions, it makes an ass of you and me. Make sure you gather of all of the documents and review them. Special conditions are particularly interesting. Basically, special condition, if you've never seen one, it usually is this whole separate document. So you've got a contract and you've got a set of general conditions that say what they say. Payment is due 30 days from the date of invoice. Very clear. You read that, you interpret it, you say, oh, I know what's going on here. Special conditions are a separate document that say something like amend clause 45B to change 30 to 60. Now all of a sudden you have this other document over here, a special conditions that changed your 30-day invoice payment obligation to 60 days. If you've never seen the special conditions, you don't know about it. You think 30, like you look at the general condition, you think 30 days is 30 days. Makes sense. It's clear. I don't need to think about anything else. If there are special conditions out there, and they're not that common, but they do happen, make sure you look at them all together and you see that 30 has been changed to 60. Here's an example, if you're looking at my screen here, of just a typical or fairly typical incorporation by reference clause. Another thing that you will often see omitted from your clause, and we'll see an example of how that can go here, is your proposal. So you submit a proposal to your owner, to your contractor, whatever your role is in the game, and you say, hey, I've excluded some things, I've made some assumptions, I've made some qualifications here. This is my proposal based on those assumptions and qualifications. and here's my number, here's my bid. And then you go to contract, and your proposal is not part of the contract documents. Those qualifications, those assumptions, those things you omitted, not part of your contract anymore. Okay, if your proposal is not listed in the contract, it's not a contract document and nobody's bound by it. And your average sophisticated owner, contractor, general contractor, subcontractor will not allow you to add your proposal as a contract document for that very reason. They don't want your assumptions and qualifications part of the document. You let them get away with that, it can hurt you. We'll see some examples here in a bit. Sorry. What if there's a conflict in your documents? So we've got a bunch of construction documents, a bunch of things incorporated by reference. We've got a general contract, we've got a special conditions, we've got general conditions, we've got plans and specs, and all these things that are incorporated by reference. Conflicts are going to happen. You know, nobody's perfect. There's no such thing as a perfect construction project. There's no such thing as a perfect construction contract. So what if there's a conflict? What do we do? How do we fix it? What if the plans say I need 1/2 inch drywall and the specs say I need 3/4 inch fire rated drywall? What do we do for the same exact location? How do we resolve that? Well, your average contract will say what rules, and it's usually the specs. For whatever reason, the AIA documents and other contracts will say to the extent that there's a conflict between plans and specs, the specs win the day. But if there's not, and there could be conflicts in other things, it could be conflicts. We talked about flow down provisions. I've got a very specific contract with my general contractor, and now I've got this flow down where I'm bound by the obligations the contractor has to the owner. For the first rule really is, the more specific is, unless there's something to the contrary in the contract, if there's something that says the specs rule the day, then the specs rule the day. But if there's a conflict between the plans and the specs, and there's no conflict, it's whichever one is more specific. And in the case of the flow down clause, the subcontract between the subcontractor and the general contractor is more specific because that's your deal. So if there's something in the general contract that has flowed down to you that conflicts with your subcontract's gonna win the day. So you try to resolve it that way, but sometimes there is no resolution and there's a conflict. Let's say your contract, for example, is quiet. It doesn't say when payments due. It doesn't say payments due in 30 days. It doesn't say payments due at the end of the project. It doesn't say anything. It just says you'll get paid. And you have an expectation that you're going to get paid in 30 days, and the owner has an expectation that you'll get paid at the end of the project, but there's nothing in the contract documents to speak to that. How do you resolve it? Well, the first thing when the courts, if you have to get the courts involved, first thing the courts do to try to resolve a conflict like that is they look at the contract. And we just said that there is nothing in this particular contract to resolve that. Normally, a contract is what it is. It is binding and enforceable if it is specific on a topic. So if there is a clause that says you get paid in 30 days, that's it. It's called the parole evidence rule, PAROL, no E on the end. If a contract is clear and unambiguous on a topic, then nothing else comes in. No other evidence comes in. Even if we had a discussion that says, yeah, I know we got this contract that says payable in 30 days, but hey, I'll pay you in a week because I know you have cash flow issues. It's not enforceable if it's not in the contract. You can have testimony about it. You can have emails about it. You can say, hey, I know we had this deal, but Joe Blow or Mary Blow said that they would pay me in 7 days. It doesn't matter. Courts have to enforce the contract as it's written within the four corners of the documents, as lawyers say. Nothing else comes in, because if people start losing faith in written contracts that are unambiguous, then the economy suffers and children die. We have to have faith in contracts. Okay, so if your contract says 30 days, it's 30 days. Parole evidence rule. Nothing else comes in. It's a very important thing that you need to know about. If you have all this other evidence in the world about another deal and it's not part of your contract, it's not incorporated by a change order, it doesn't matter at all because the jury will never hear about it. So if there's a conflict, is it 30 days? Is it 60 days? I understood one thing, you understood another. First thing a court's going to look at is the contract. And if the contract is clear, that's the last thing it's going to look at. But if the contract's not clear, in our hypothetical here, what's next? The contract's not clear. Contract doesn't say you get paid in 30 days or 60 days or whatever. The contract just says you'll get paid. And we're arguing about when. Next thing, the contract will allow that parole evidence in. It will allow you to introduce emails. It will allow you to testify on the stand if it comes to that regarding, we had a conversation. It's not in the contract. Contract's unclear, but here's this email. Here's my testimony about how this person said they'd pay me in 7 days. They'd pay me an extra 10% to get the project done a month earlier. They do this, they do that, okay? So if you can get it in writing, it's the best way. Everybody jokes about oral contracts. Oral contracts, for the most part, are enforceable. However, we joke that oral contracts are not worth the paper that they're written on. Because they're not written, because it's your word against theirs. You can prove your oral contract is a thing, then good for you, but it's hard to do without something in writing. Same thing with change orders. You can go to a job meeting on the project where something comes up and something changes and an owner tells you, do this extra work, I'll pay you for it, time and material, track it, you're good. You never get it in writing, and then at the end of the day, you submit an invoice for it and they tell you to go away because it's not part of your contract. It's not fair, but it's right legally, sadly. So get it in writing. If it's not in writing, again, going down the chain of conflicts here, the first thing that a court ever looks at, if you're in litigation, if you're in dispute, and it doesn't come to litigation all the time, I get that. A lot of times you're just in a conference room with your client trying to get paid extra for what you deserve to be paid extra for. There's no lawyers involved, there's no court involved, it's just business folks doing business things. And even in that situation, you want to be well documented. You want to be able to show them, hey, you told me to do this. You told me I was going to get paid for this, and now I'm here asking to be paid for this, and you're giving me a hard time about it. You want to make sure that doesn't happen. The best information I can give you in the world on this call, if you don't take anything away from this other than what I'm about to say, take this away. Send that email. You go to a job meeting with your owner, with your general contractor, whoever your contract is with, and they tell you to do something that is an additional scope item that's going to cost your company more money, and they tell you you're going to pay for it. When you get back to your office, you send them an email and you say, hey, it was great seeing you today. I love you. I appreciate your business. For my understanding of our conversation, you want me to do X, Y, Z, and you're going to pay me ABC for it. Please let me know if I got that right. Hugs and kisses, whoever you are, send. 9 out of 10 times, no one's going to reply to that email. So what? You've got it now. If they don't reply to it, that's on them. You've got a document that says, this was our deal. My dog, sorry about that. This was my deal, and this is what it looks like. And if you have a problem with it, say so. 6 months later, a year later, when you're trying to collect on that project and they're giving you a hard time about it, saying, we never said this, you send them that email and say, hey, we had this deal. I gave you an opportunity to reply to it. You never did. And this is what it looks like. That is powerful in any situation. It's powerful in court for me. It's powerful for you in a conference room with your client. You want something that says, this was our deal, and they didn't reply to it, and that's a problem. So getting back on slide here, if there's a conflict, the first thing the court's going to look at is the contract. If the contract doesn't talk about it, I'm going to have to go deal with my dog here in a second, I think. The contract doesn't talk about it, then the court will allow that parole evidence in. They will allow testimony. They will allow those emails. You know, if there was an email that said, I'll pay you in 7 days, if there's a person who can testify, that person said they'd pay me in 7 days, that all comes in. But what if nobody talks about it? What if there is no evidence? What if there's no emails? What if there's no testimony? Like, it's never been spoken about. Now we just have to figure it out. What's next? The next thing the court's going to do is look at common business. Actually, I'm sorry, I skipped a step. The next thing the court's going to look at is whether or not y'all have done business before. If this is your 10th project together and every other project has been net 30, and now all of a sudden somebody's trying to change the game, if there's nothing in the contract, if there's no other emails or testimony about it, the court's going to go ahead and look at what you've done before. And the court's going to say, hell, this was your 10th project together. It's always been net 30. If you didn't want it to be net 30, somebody should have said so. The next thing after that that the court is going to look at, if there is no, so there's no contract, there's no other evidence, there's no prior business relationship or other guidance to look at. The next thing the court's going to look at is, what does the Cincinnati market look like? It's basically this place, this time. Is net 30 normal? Is that a reasonable expectation? Is that what always happens in construction? If it is, then that means a lot. The court's probably going to apply that. No one can say for sure what a court does. That's a thing, obviously, I live with every day. You think the court's going to do one thing and then they do another. But that's the next standard. If you have a situation where in Cincinnati 2020, net 30 is the standard, and you can prove that to the court, and the court's going to say, well, obviously it's net 30. It's not next year when the project's done, it's net 30. And the last thing that the court is going to look at is whether or not there's any case law in point. As the slide says, precedent is a thing. When a court reaches a decision on a legal issue before it, it writes an opinion. And that opinion gets published to the world, and it's binding. And a court opinion stays that court's opinion until it changes, and it often doesn't change. So if a court says, we've reviewed this and we hereby think that, for example, a 30 days is mandatory. That's not a thing. I just made that up as a court provision. But a court says, we insist that 30-day payment is required in all construction contracts. Until some other court comes along and overrules that, that court is bound by it. And if it goes up to the Ohio Supreme Court, which governs the whole state of Ohio, the whole state's bound by it. So precedent is a thing. We have to go back and look and see how courts have treated this before and figure out how they're going to treat this one based on how things have been treated before. So that's the gauntlet, basically. What's in the written contract? If you can't solve it from that, what other evidence do you have? If you don't have any other evidence, we look at your prior dealings with each other. You've never dealt with each other before. We look at the industry, and if the industry can't answer the question, we just go to the cases. So that's the gauntlet. You don't want to run the gauntlet. You want to make sure your contract is clear. Is the point of all this. You want to make sure your contract says net 30 or whatever your payment terms are. Got some fun examples here of incorporation by reference and how the contract documents work. This particular example right here, this was a project down in Louisville, Kentucky. If you've ever been to Louisville or driven down there, even just on the freeway, you can see there's a lot of rock. There's a lot of rock excavation. They've dug basically everything they've built out of rock. So this was a general contractor in Louisville, fairly sophisticated, good-sized general contractor. But they were doing business with a developer out of Tucson, Arizona. And a lot of you have probably figured this out already, but it bears repeating anyway. Beware the out-of-town client. If you're doing business with somebody in town or in the region, there is an incentive for that entity to be fair, because they're probably going to see you again. They're going to develop a reputation, and they are hopefully going to want to have that reputation be positive. You're dealing with an out-of-town carpetbagger type of entity. That incentive isn't always there. It's often not there. So if they do you wrong, if you walk around town talking about how dirty and crooked they are, they don't care because they're not coming back. This is that type of situation. So we've got a Louisville contractor here building. It was like a call center type of project. You can picture it, I'm sure. Not the most sophisticated project in the world, but still, you know, a decent project. So they're building this call center, and they got this Arizona developer. And you know, usually contracts are negotiated via email. You know, I mark it up, you email it to me, you mark it up, you email it back and forth until we get it done. This particular project was not done that way. It was done in person. So originally, the general contractor had a qualification in their bid that said, hey, this is Louisville. I know I'm going to hit rock. I know this. I don't know how much rock I'm going to hit, but I know I'm going to hit rock. And because I don't want to go at risk for this unknown thing, I'm excluding it. I'm giving you a lump sum bid with a qualification that says, I exclude rock removal, and I will do whatever rock removal needs to be done at $50 a cubic yard. I don't know what the price was, but you get my point. So lump sum price excludes rock. I know I'm going to remove rock. It's going to cost this much per cubic yard. So Mr. Arizona flies to Louisville, and they all get in the conference room, and they negotiate this contract. So you get a very clear proposal that says no rock. Somewhere in this negotiation of contracts, the proposal gets omitted. In the original drafts of the contract, the proposal was a contract document. It said this proposal, you know, says what it says, and it's incorporated herein. Well, Mr. Arizona was savvy and clever and was able to talk the contractor into excluding his proposal from the project. And instead, they incorporated the soil report into the contract. Now, the soil report is what you see here on the screen. It says, this contract basically says, I have seen the soil report dated May 3rd, 2001, and I'm good with it, and my number includes it. That's not true at all, but it's what the contract says. The contract doesn't say anything about excluding rock removal because the proposal is not a contract document anymore because it didn't get in there. Instead, I've got a soil report included in the contract document, and that soil report says, this is from the soil report, it says basically auger refusal everywhere. Auger refusal is the way that geotechnical engineers say we hit rock everywhere. So we went from having a proposal that says, I don't include rock, not in my number, it's separate, it's T&M at this price a cubic yard. That's gone, and instead we have a soil report that says you're going to find rock every single place you put a shovel in the ground. That was the contract. And that gets us to dispute resolution. In that particular case, the developer was my client, the one who did the switcheroo. I wasn't involved during the switcheroo part. The projects generally come to me after they're broken, not when they're being negotiated. I do construction contracts a lot, but it's probably 10 to 1 resolving litigation after a project has gone south on a contract I had nothing to do with. So in this particular project, that deal said what it said. And this is where the parole evidence rule rubber meets the road. Okay, you've got a proposal that says, I exclude rock, it's $50 a cubic yard. That proposal is not a contract document anymore. On its face, the contract is crystal clear that you have the soil report incorporated, you've looked at it, you've considered it, and your price includes it. In a court in any jurisdiction in this country, your proposal that says I exclude rock is never coming in. Parole evidence, it's out. The contract is clear. Your SOAR report is part of this deal. You've looked at it and you're stuck with it. You negotiated a bad deal. You're a fancy business person. This is a 6-figure, 7-figure, whatever contract. You should have done better. Sorry. And you think to yourself, dear God, how can that be? How can they not look at that? Because they can't. Courts have to enforce the clear language of a contract, because if they don't, people stop believing in contracts. If contracts can be wiggled out of that easily, then what's it worth? That's how a court looks at it. You knew better, you should have done better. Which gets us to the dispute resolution clause, and to some extent I'm giving away my own punchline here, but it bears talking about. In this particular case, there was a dispute resolution clause that said that rather than litigating, we're going to arbitrate these cases. And if you don't know what arbitration is, I'll tell you right now. Basically, litigation is you go to court, you do your thing. It's what you see on television. Arbitration is an alternative to that. That's why we call it alternative dispute resolution. So arbitration in a lot of ways looks a lot like court. You have witnesses, you have direct examination and cross-examination, you have exhibits, you often have openings and closings, you have your witnesses. But instead of happening in a court with a judge and jury, it happens usually in some attorney's conference room with an arbitrator. And there are a lot of advantages to that. It's usually faster, it's usually cheaper. And my favorite part about arbitration is your judge and your jury, if you're not arbitrating, doesn't know a thing about construction. They don't know what a change order is. They don't know what PSI is. They don't know anything about the entire industry. And trying to teach them the construction business while you're trying to convince them that you're right is difficult. Your average arbitrator in a construction dispute is going to be somebody who knows the business. It's going to be a construction attorney, an engineer, a general contractor, just a sophisticated construction professional is the point. So arbitration, to that extent, I like it better. Like I said, it's faster, it's cheaper, and you've got somebody who knows what they're doing. And as an added bonus, your arbitrator is going to come to a decision. They're going to say, I've reviewed all the evidence, I've heard these witnesses, I've seen these documents, I've looked at them carefully, and this is who wins and this is who loses. And they're going to write that down, and you can take that written document to your courthouse and file it, and it will be enforced just like a judge and jury did it. I recommend, matter of fact, I went to a legal seminar thingy once upon a time where a bunch of judges were talking about things that judges talk about, and somebody asked the question, what types of disputes are better suited for alternative dispute resolution, i.e. arbitration? And I happened to have a case right before that judge, and when he answered the question, he looked me right in the eye and he said, construction cases. Arbitration is better for construction. It just is. But to bring it back to this example with our Louisville contractor and the rocks, another big difference, at least between arbitration and litigation, is the parole evidence rule in arbitration. It's gone. Okay, arbitrators are not required to obey things like precedent and the parole evidence rule and things like that. So a jury would never, ever, ever have seen the proposal that said rock is not part of this contract. Lawyers file motions where they get things like that excluded. It'll say, Judge, before we get to trial, this document that they're going to try to introduce, they can't introduce it. We've got a clear contract. It's on point. Parole evidence rule, it's gone. And it probably will be gone if you go to an actual trial with a judge and jury where precedent and the parole evidence rule matter. In arbitration, civil rules of procedure, rules of civil procedure rather, rules of evidence, all those things are softened if they're not omitted completely. Everything comes in at arbitration. And arbitrators are a lot more free to do what's fair or equitable than a judge is. A judge is bound by law to enforce the clear terms of a contract, whereas an arbitrator can say, well, contract says this, but you clearly understood that this contractor was expected as an added bonus in my as my case study here. Every month, Mr. Arizona flew to Louisville to check on his project, and every month, the general contractor handed him a handful of tickets from the trucking company that removed rock and said, "Here's this month's rock removal number. Keep going." Mr. Arizona said nothing because Mr. Arizona believed in his contract. And if he had been in court, and maybe things are different in Arizona, I don't know, I don't practice there, but he believed that he would be able to enforce his contract. And even though he had a proposal that says rock is removed, even though every single month the general contractor handed him a stick of tickets that said, "I expect to be paid for this," he thought he would get out of it. And in court, he probably would have. And maybe even in Arizona arbitration, he would have. But I said, we represented the owner and we said, you know, you ain't from around here, is you? In Louisville, Kentucky, this is going to hurt you. You should settle this. You should pay something on this because this human being clearly didn't include these numbers in his price. And he every month reminded you he expected to get paid for it. And you're just being kind of cagey. And an arbitrator in this part of the world isn't going to like it. He decided to take his chances, and we arbitrated it, and we lost. And I don't feel bad that we did because that contractor deserved that money. We did the best we could with it. We argued parole evidence. We argued the law. But at the end of the day, what was fair was that contractor never intended to go at risk for rock, and he deserved to be paid for it, and he did. The point of all of this, though, is that that could have easily gone the other way. And you don't want to be on the wrong end of that. You want to make sure that your contract says what you think it says. If you don't even want to incorporate your proposal into a contract. If something is important to you, don't say, "I incorporate my proposal." You have it written into your contract. You say, paragraph 35B, we're not going at risk for rock. It's $50 per cubic yard. That's the best way. But just don't leave it up to chance. But if you do leave it up to chance, arbitration is going to be a lot friendlier to you than litigation is. Documentation guidelines: be clear, simple, and specific. Be timely. Document everything. Your lawyers are going to drive you nuts with how much documentation you should have, and I appreciate that there is a balance there, that you have projects to build and you have things to do, and it's difficult to document everything. But do your best. There's a joke that lawyers like to tell. It goes like this: if you have the law, pound the law. If you have the facts, pound the facts. If you don't have either, pound the table. I've revised that joke for construction, and I'll take this deal all day long. I would rather have the documents than the law and the facts. The company, the business, the person with the best documentation usually wins. Whatever the law says, whatever the facts say, is subordinate to what is well documented. I understand you can't document as much as I would have you if I were involved, but document as much as you can. Do it timely. Keep your tone balanced. Don't editorialize. Don't say things like, "This is the stupidest person I've ever talked to," if you can. That might be used against you. When you're doing your estimates, keep everything. Keep all of your documents, even if you screw something up. Back when I was still estimating, a lot of it was done by hand, so forgive me if my advice is a bit dated here. But back during my estimation days, you'd have a takeoff sheet and you'd write a lot of things down, and maybe you'd screw something up. Maybe you didn't appreciate that it was quarter scale instead of half inch, and you'd have to revisit that. Don't throw that page away. Put a big X through it, or whatever the electronic equivalent of that is, and say why you're doing it. Say why it was wrong, because you're going to potentially want to retrace your footsteps someday. It's like back when surveying was done by hand. Legally, surveyors were not allowed to scratch things out. They were not allowed to tear pages out. They were not allowed to blur any of their work, even if they made a mistake. Because if 10 years from now, 100 years from now, somebody needs to go back through and get through that surveyor's mind, they need to trace the entire path. even the mistakes. And if there's an omission because a page was torn out, you can't do that. So keep your mistakes, document why they're mistakes, and keep them legible, put a date on it, put your name on it. Stay solutions focused. Don't be too much of a Debbie Downer or a Donnie Downer. Try to be positive. Follow your contract requirements with regard to documentation and close the loop. You know, if you send an email to somebody that says, I need your reply within 14 days, if 14 days come and pass and you've not gotten their reply, say, hey, I haven't gotten your reply in 14 days. These things are all valuable to you when you need to resolve a dispute. And again, when I'm talking about disputes, I'm not talking about judges and juries and lawyers. I'm talking about you in a conference room or on a phone call with your client that says, we had a deal and you're not honoring it, and I've done everything I can. Here's the documentation. What say you? I had a project once where I was a subcontractor, as I've said, and I had a general contractor tell me if I did this additional scope of work, it's the same old story. You've all dealt with it. General contractor says, yeah, this isn't in your scope of work. Track your time. We'll pay you for it. Should have gone back to my office and sent an email and said, for today's subcontractor meeting, you said for me to do this, and if I track my time, you pay for it. I didn't do that. 6 months later, the project's done. I'm trying to get paid. I never said that. Close the loop. Make sure you've got those documents. Make sure you've got, I could have pulled out an email if I had been smart enough to write one and said, hey, remember this from last July where you said this right after the subcontractor meeting? Did you reply to this? No, you didn't. That is powerful in any situation. It's powerful in a courtroom, and it's powerful in a conference room. It's more powerful than sitting there just saying, well, I think you said this, or I'm telling you you said this even though you disagreed. Your email that day that says, you told me this, is a lot better, a hell of a lot better than nothing. Other important documents. We're going to look at examples here: daily reports, correspondence, meeting minutes, job cost reports, pay applications, and photos. These all matter. Pay applications are my favorite, and you'll see why here in a little bit. But daily reports are a big deal too. We got an example here on daily reports. This one's fun. This is an actual project. This was a contract for 2 schools. One contract for 2 schools built by the state of Ohio, the OFCC or the OFIC, I think it was at the time. So I've got a contractor here, electrical contractor, that thinks they're due extras. The request for equitable adjustment is unique to the construction industry, and it's a thing that I will never, ever understand. But you will see it. Maybe you've done it. Try not to, please, if you can help it. But a lot of times, or not a lot of times, but sometimes a contractor or subcontractor will finish a project. They will perform. They will never say a word in the world about anything inequitable at all. Just do their job, get done, get paid, hit equals on the calculator, and realize they've lost a ton of money on this project for the first time. The project's a year old. They didn't realize they were losing money until the end of the project. That happens a shockingly frequent amount of times. I don't understand it. Like, how you don't know that you lost money on this project until it's over with is a mystery to me, but it happens a lot. And when it does, some contractors will kind of distort a contract clause that's in the AIA documents and a lot of other documents, and they will submit a request for equitable adjustment. And they will say, this project's done, I'm paid in full, but I just realized that I lost a ton of money on this project, and I require you to pay me extra or else I'm going to sue you. And they will come up with a reason why it's not their fault every single time. Bad plans, bad owner, bad construction manager, whatever the case may be. They'll figure out a reason to pin it on. And they will submit this request for equitable adjustment. This is one of those cases. So this is a contract for 2 schools. Project's done, everybody's paid, and then all of a sudden the electrician needs extra money because of, for whatever reason, on this particular project, they said that the plans were poorly prepared. So If you don't know, when you get into litigation, there's this thing called discovery. And discovery means everybody gets to see everybody else's stuff. Everybody exchanges all their documents. The only thing that's really off limits is your communication with your attorney. And often it's not, your attorney wasn't involved during the construction of the project, because why would they be? So everything is exchanged. So all of those intercompany personal documents that you thought no one else would see, guess what? Everybody gets to see them now. So your daily reports, your estimate, job cost reports, all of that is getting sent to the side that you're suing for money. And they're going to send you all their stuff. So everybody gets to see everything. No secrets. No Perry Mason moments anymore, really. Perry Mason happened before discovery. That happened in like the 70s or something, where the rules changed and discovery became a thing. Now everybody gets a document. There's no hidden smoking gun. Everybody gets to see everything. So we've got this dispute with this electrical contractor that finished these two schools on this contract, and they're saying equitable adjustment, we lost money, and you need to pay us more. It's your fault, bad plans, blah, blah, blah. These are excerpts from their daily reports. And as you know, but I'll say it just in case, daily reports are a thing that's generally kept by the person in charge every day on the job site, the superintendent or foreperson, whoever the case may be. Whoever is there on site day in and day out has a form that they fill out, talks about what happened that day. And if they are done well, they can be a powerful tool in dispute resolution. We had one case, for example, where a crane and equipment supplier had very careful reports about how his equipment sat idle for days and days because of the inability of the construction team and the owner to get their act together. And we were able to use those daily reports to quantify just how many hours of lost equipment time they had. And I mean, we had a chapter and verse. This crane sat here for X days. This backhoe sat here for X days. I mean, we had it detailed. Documentation, again, is everything. This is an example of daily reports gone wrong, gone wild. This is that same electrical contractor's superintendent, foreperson, whatever. He writes, job sucks. All equipment on school 2. Provided equipment 1 minute. This was the superintendent on school 1, by the way. Two different superintendents on each school. Job sucks. All equipment's on school 2. Produced equipment 1 minute, changes mind the next. Progress held up by masons, HVAC, and now Bob. Bob was his boss. So he's blaming his boss for lack of getting things done. Installing temporary lighting in the right wing off of ladders. Bright idea. Job wide nooner for most electricians. No lift on job. Have to jump start piece of shit job truck. Now, that's funny. And these are not cherry-picked examples. This man clearly hated his job and his company because he had about a year's worth of things that looked like this. Talking about discovery, the first thing you do is you exchange all of your documents with the other side. The next thing you do is you get to depose all of the key witnesses from the other side. So Mr. Job Wide Nooner here has written up his daily reports. The primary witness from this company is obviously going to be the person in charge of it, the CEO, Bob in this case. So Bob has to come into a conference room with a court reporter, swears to tell the truth, the whole truth, and nothing but the truth. So help him God, and has to face over a year's worth of reports that look like this. And the reason that depositions are a thing is so that, again, no Perry Mason moment, the attorneys know what you're going to say when you get to trial. So Bob gets deposed. Bob gets faced with all of these documents, all these daily reports. Bob says what he's going to say about them. And then 6 months, 2 years, whatever the case may be later, this case goes to trial. Bob's going to have to testify about these reports. He's going to have to look at them again. He's going to have to talk about them again. And if Bob says something different than he did back in his deposition, before God, sworn before God under oath, and there's an inconsistency, Bob's going to look like a liar. So if Bob said in 2005, after looking at the documents, the stoplight was red, and then in 2010 at trial, Bob says the stoplight's green, the attorneys are going to pull out the transcript of his deposition. It's in there, getting written down by a court reporter. And he's going to say, well, that's funny, Bob. You just testified before this jury, the stoplight was green. But back in 2005, with your hand to God, when you had more familiarity with the matter because it was more recent, you said it was red. Were you lying then or were you lying now? We're not allowed to say that as lawyers, but the point still gets made. So, discovery. They get all your documents, and then they get to ask you questions about all your documents, and you're kind of stuck with whatever you say. And this is what it looks like. This is how Bob's deposition looked. He says, quote, this is the attorney, it wasn't me. But it was an attorney, he says, quote, job sucks. All equipment on school number 2. Promised equipment 1 minute, changes by the next. Progress held up by Masons, HVAC, and now Bob. Who is Bob? That's me. So your guy on site indicated that you were holding up progress on school 1, right? That's what he indicates. Now remember, Bob and his company have requested an equitable adjustment. They expect to be paid above and beyond what was in their contract because of bad plans or whatever. And now they're looking at a year's worth of construction documents that say their company sucks, that it's their fault, that they're behind. What is a job wide nooner for most electricians? No lift on job, have to jump start piece of shit truck. What is a job wide nooner? That means they left at noon and didn't come back. That's right. Why would they care about a piece of shit job truck if they had no work available to them? Again, I scheduled these guys. He's reaching. And this is the crux of it right here. If he was having a lot of problems maintaining efficient work on this project because of equipment problems with the equipment that was being provided by you, Bob, and he didn't say anything, whose fault is that? Is that the school district's fault? Nope. Is it the CM's fault? Nope. Architect's fault? Nope. Any other contractor's fault? Nope. Whose fault is that, Bob? It's yours. So you and your request for equitable adjustment, or even if this was a legit change order, something that you deserve to be paid for. If you've got field reports that are sabotaging your interests, be aware of it. Know better. And tell that person who's writing them down to knock it off or else, because daily reports matter. Daily reports often go disregarded, but if a project goes into claim, people like me are going to read them, and we're going to make hay with them. And even if they don't go into claim lawyer style, you can still use them to demonstrate how much lost worker hours there are, how much lost equipment hours there are, and put together a number that makes sense, that is practical, that is backed up. No one's going to pay you for a pie in the sky. I lost this much money, so that's what you owe me. X minus Y equals Z type of number. No one's going to do that. But if you can say, hey, I was delayed, it's your fault, and here are my daily logs that say I had this many workers, I had these pieces of equipment, this is what they cost me, this is what you owe me. That is a much better argument. So do that. Job cost reports are my very favorite thing. I look at the job cost report before I look at anything else. Meeting minutes are great, daily reports are great, but job cost reports are a thing. Anytime that you ever go to court for anything, it doesn't have to be a construction contract thing, anything, personal injuries, defamation, take your pick. There are two parts of winning a lawsuit. One is you have to prove you're entitled to it. Somebody did you wrong, somebody broke the law, somebody breached a contract, whatever the case, whatever type of case, you have to prove that happened. That's the first part. And it's the part that most people focus on, even lawyers. That's the part that even most lawyers focus on. The second part that a lot of people ignore, that a lot of lawyers ignore, frankly, is what did it cost? What are the damages? And can you prove it? And if you can't, okay, You broke the law. You were driving negligently. You crashed into me. I got hurt. My car was damaged. Here's the value of my car. Here's the value of my medical bills. Here's the lost income that I have to deal with. Here's the loss of maybe, if I'm seriously hurt, income over the rest of my lifetime, blah, blah, blah. Those are all things that you have to prove. And if you don't, no one's going to give you $10 million just because you say so. You have to back it up. And that makes sense in a personal injury situation, but a lot of construction practitioners lose sight of that. A lot of construction folks will say sometimes that, hey, I had a bid to do this project for $1 million and you sucked, Mr. Owner, Mrs. Owner, Mr. Architect, Mrs. Architect, whoever you want to blame it on. Something was wrong here and it cost me $1 million too. You owe me $200,000. That's the difference. That is a loser. It's called the total cost method, and every single court in this country will throw it out. You don't get to do, I bid X, it cost me Y, ever. It's not a thing. It's a loser. It probably won't even get to trial. It's such a loser. It'll get thrown out before that. You can't do the X minus Y thing. You have to prove specifically what this thing cost you. The reason why I lost $200,000 is because of the owner didn't get a permit in time, and I had 50 pieces of equipment sitting there making no money, and this is what I bill my equipment out every day. 50 pieces of equipment per day times this number times this many days. You've got something there. You can't just say I lost $200,000. And that's why I love the job cost report so much. It's because it's an often disregarded document. And even myself, back in my construction days, we had a project managers meeting every Thursday, and it was the worst day of the week, every single week, where the owner of our company got all of us together, all of us project managers, and there were like, I don't know, 10 of us maybe. And we had our job cost reports in our hands, and we went through in front of each other, line item by line item, every single thing on a job cost report. And if for some reason you don't know what a job cost report it is, I'll break it down real quick. Your job cost report has every single thing that costs your company money broken down in excruciating detail. So I was a drywall contractor. We would have drywall, material, drywall, labor, finishing material, finishing labor, framing material, framing labor. And if this was a 5-story project, we'd have drywall material, floor 1, drywall material, floor 2. If it was a 5-building project, floor 1, building 1. They get long, they get complicated. I'm sure you appreciate what I'm talking about here. So we went through all of that excruciating line item by line item detail, and it did not matter. You could be 90% done on a project and 50% under budget. And if you had a line item that was screwed up, you had some explaining to do, regardless if you were killing on a project. If you had a line item that was off, my boss wanted to know why. And I thought it was the most ridiculous thing and the biggest waste of my time in the world. And I was like, why is this man so anal? Well, now I know. Yeah, live and learn. It's because the job cost report tells the story. Again, you can prove that I was done wrong. This company breached the contract. If you can't prove it, if you can't show how much it cost you, then it doesn't matter at all. And the way you normally prove it is through that job cost report. So that's where I start. They say they owe me $1 million, or my client says they're owed $1 million. Let me see what the job cost report says and make sure I can understand that whether they're right or wrong. And if they're wrong, I deal with that. If I've got a client that there are ways to proceed even if the documentation isn't in order. There's always an argument to be had, but at the end of the day, man, like I said, I would rather have the documents than the law or the facts. So if they've got documents that show I had this stuff sitting here all this time, it makes my job recovering money for them or defending them from somebody trying to recover money if the documents aren't there much easier. So track them diligently, keep them honest. I remember that I used to cheat, to be honest, because my boss was so particular about our job cost reports, and I knew that if I had a line item that was over budget, I would, bury money in a place where I had money to spare. So if framing was done, 100% complete, we're all framed up. And I spent 50% of the budget on framing and did a good job project management wise with that. And then I get to drywall, and for whatever reason, I'm over budget on drywall, and I recognize that I'm about to exceed my 100%. Might bury that money in framing because I don't want to have to explain it later. Human nature, the thing. And I did it. I understand why that's a problem now, and I didn't then. It's a problem because let's say the reason you're over budget on drywall is somebody else's fault. And let's say it winds up costing your company a ton of money. And you're entitled to be paid an additional ton of money due to no fault of your own. It becomes very difficult to prove how much you're entitled to if you've buried that money in other cost codes because you were afraid of having to be accountable to your boss. So all of a sudden, I want a $100,000 change order for extra drywall because of, for whatever reason, but you print out my job cost report and I haven't gone over budget at all on drywall because I've buried it in a bunch of other things that I saved money on. That's a thing. So pay attention to it and think about it, and counsel your people to pay attention and think about it. So getting back to the slide here, keep your job cost reports honest. Use the separate cost codes for change orders. That's another big one. If you have a big change order, it's going to cost your company money. Track it separately. Make a new set of line items on your job cost report, on your pay applications for it. If you bury your change orders in your contract work, it's the same story. It's the same thing I just talked about. You're going to have a hard time figuring out what you're due and proving, more importantly, what you are due. So if you've got a change order, this big extra, separate it. That way, if it goes to litigation, if someone says, I'm not paying you for that, you don't have to try to separate the wheat from the chaff anymore. I've got my contract worked over here. I've got my change order costs over there. And I can prove to you, and again, damages to me are everything because so many people screw them up. We can talk about whether or not you're actually entitled to this money later, but you have to prove to me first that you can actually show it, that you can demonstrate the actual quantum of what you're asking for, and it isn't just this X minus Y thing. So change orders, if it's even a little change order, if you can, I would recommend breaking out every single change order into a separate line item in your pay applications, in your job cost reports. But definitely the big ones. If you see something as a dispute, even if it's a thing that someone says, I'm never paying you for that, I disagree with you, that's contract work, it's not happening, track it separately anyway, because you're going to need to prove that. And if you start integrating it with things that you agree with versus things that you don't agree with, it gets tricky. You don't want to be there. Here's an example. I hope you guys can see this. I'm not sure if you can, but even if you can't, hopefully I'll talk it through. Jen, is everybody hanging in there? I haven't checked in a minute. Is everybody good?
Yeah, everybody's still on here.
Okay, you can hear me, you can see these slides, yada, yada?
Yep, you're good.
Cool. All right, this is a project where this was a plumbing and mechanical scope of work on a commercial project in Cincinnati here. The contractor submitted 2 separate bids, one for plumbing, one for mechanical, and then they submitted a combined bid with a discount. If you give us both scopes of work, we'll do it for cheaper, which makes sense, obviously. And these numbers aren't important other than to show that there was a base contract, there are some change orders, as there always are, and there's a total revised contract of $2.6 million. Not a small project, obviously. So we got a mechanical plumbing combined contract for 2.6. This was another one of those cases of a request for equitable adjustment, where a contractor comes back and says, you owe me more money just because the project sucks and I lost money on it. In this particular case, again, they blamed the architect and the construction manager. Our plans were shit and construction manager did a bad job. Give us extra money. We represented the construction manager in this case. Again, discovery is a thing. Those job cost reports that you thought were confidential company material, they get exchanged with the other side. In this particular case, however, they shared them with us and tried to demonstrate, look, we told you we lost money, and here's evidence of that. Job cost report is a long document, many pages long. This is literally the bottom line. This is the equals on the project, and this is just a screenshot of the plumbing package and the mechanical package. And it basically says, look, we told you you screwed us. We lost $282,000 on one package, $156,000 on the other package. All in, we're $438,000 down because of you. Well, job cost reports show it. We lost money on this one. Again, this is one of those X minus Y equals Z things. It is a loser, but people do it all the time anyway. We bid it at this. We lost that much. It's your fault. Plans and specs suck. So again, we got all their documents. We didn't just get the job cost report. We also got their bid. We'll get to that in a second. But you can reverse engineer from their job cost report. You can reverse engineer what they thought their profit margin was going to be. Just a little math. And you can see that they expected, per their job cost report, and this is important, per their job cost report, they plan to make a margin of about 11.6% on this job. Because you can see what their costs were anticipated to be, and you can see what their bid was, and you do a little math, and in this case, they're saying we anticipated making 11.6% on this project, and instead we lost $420,000. Equitable adjustment, you owe us money or else we'll sue. When you do discovery, you get their bids too. You get their estimates too. You get to see what went into that proposal that they agreed to. And in this particular case, this is the plumbing estimate. And these individual columns you'll see here, 5%, 6%, 7%, 8%, 9%, 10%, 11%. This is apparently some sort of intercompany spreadsheet that shows what their proposal is going to be based on a certain profit margin. And on this particular project, they decided to go with an 8% profit margin, which showed $364,000, which again, when you do the math, is about 2.25% profit margin. But this is on the plumbing scope of work. You don't even have to do arithmetic on the mechanical part because they wrote it down. Total estimated costs, overhead and profit, 3%. That's on the mechanical. They estimated 3% on the mechanical, which was the bigger scope of work, 2.25% on the plumbing. And when you combine them, their actual estimate right here, bid at 1.5% to 2%. This is another one of their documents. They wrote this down when they were bidding the project, before construction happened, before there was ever a dispute over non-payment. They have a document in their estimate file that says bid at 1.5% to 2%. I don't even care anymore if the architect drew bad plans or the construction manager managed the project poorly, because you bid this project at 1.5%, and now you're trying to hold my client accountable for 11%. Like, that ain't happening. You bid this because you were hungry, and I get that. That's fine. It happens. But you can't come back to me and my client after the fact and say bad plans and specs, we didn't make our 11% profit. I don't care if you costed it that way. You didn't bid it that way. And that's another great point to make. Your job cost report, so many contractors will go and completely start the process over after they win the contract. Your job costing, your schedule of values, your entire project accounting should be a reflection of your bid. I should be able, or your lawyer should be able, or your client should be able, or the jury should be able, whoever should be able to see the project budget from front to back, from your estimate to your schedule of values to your pay applications. There should be a clear path. More often than not, you get your contract and you sharpen your pencil and you think, I don't need to make 1.5% on this one. I can make 11% on this one. And then you get wed to it. And then when you don't make it, you blame somebody else when it was never in your bid in the first place. And as a business practice, that is fine. It is good to make money. Cash flow is a big deal. I get that. But when it comes to litigation, when it comes to proving your claim, you're trying to make 11% on a project that you bid at 1.5%, it is going to be a problem for you. And you need to recognize that from the beginning so that you don't get in any deeper on a conflict than you need to. Now, these folks had some decent arguments to talk about why this 1.5% to 2% wasn't legit, and there were change orders that changed the game and blah, blah, blah. No documentation of any of it. Some of it was probably real. Some of it was probably right. They probably did deserve more than 1.5% to 2%, but they had no documentation of any of it. And without that documentation, it's really difficult to win, frankly. Difficult to persuade anybody, even if you're not in court, that you're entitled to this money, because nobody's going to give you money that you can't document. So to recap, their $400,000 claim went to $60,000 at best, based on a 1.5% margin. I even started talking about the plans for the construction management. At best, you lost $60,000 based on your estimate. And $60,000 is a lot of money to me, to you, to people as humans. But in the course of litigation, you'll spill $60,000 in less than 6 months on just filing fees and stuff like that. $60,000 is not worth litigating over, sadly. I wish it was, but it's not. So their $430,000 claim went to 60 at best. That's why the job cost report is my favorite, or if I'm on the wrong side of it, my least favorite document, because it does or undoes everything. Photographs and video, take lots of them. Take photographs of issues, things that you know are at issue that need to be reviewed later on, that you need to have documentation of, but also take projects of just the everyday progress of your project. You never know what's going to be required to be illustrated or represented or evidenced later. So you might take a picture of your crew on the topping out party, and behind them is something, some piece of equipment, some part of the project that becomes a big deal in litigation later. So take lots of pictures. Videos are good too. Don't editorialize. Piece of shit job truck. Those are things you can say out loud, like our electrician friend did in his meeting minutes. Just try to keep it, stick to the facts, just the facts, ma'am. Here's the project, here's this thing. Just keep opinions out of it. Date and timestamps are helpful. Here's a pay application illustration. And again, I focus a lot on the accounting of construction projects because it is often the undoing or the doing of a claim, depending on the side of it. This is the Toyota building, or the old Toyota building, I guess, down here by my neck of the woods. I live in Villa Hills, so I'm not very far from this project as I sit here. But the project is not that building. That building's clearly done. It's an addition to that building, and you can see the equipment and the materials sitting around. This is dated 3/19. Dates are important here. You'll see why shortly. So 5 days later, we got some columns up. We've got some horizontal members laying on the ground. And that's about it. I'm having technological problems here. The point is, there's not a lot of construction in place. I understand that it is common for steel erectors and fabricators who bill for their material once it's delivered. You get it in your shop, you've paid a lot for it, you don't want to go on credit for it, and as often as not, or more often than not, the architect or some owner's agent will come out and put an eyeball on it and say, yep, there it is, go ahead, owner, pay for it. Not the case with Toyota projects. Toyota is a big construction buyer, and big construction buyers can kind of name their terms, as was the case on this particular project. So this contract says we're not paying for anything, we being Toyota, until it's installed. If there's no steel in the air, we're not paying for it. I don't care if it's sitting in your shop. So this project, we represent the construction manager, and on 3/24, and that requirement's in the contract, in the general contract, it says we're not paying for anything that's not in the air. It was explicitly stated in the subcontract, but even if it hadn't been, flow down provisions are a thing, and contractor could have relied on a flow down provision that said, hey, this is what was in the contract that's incorporated into yours. At the end of the day, regardless, we're not paying for steel until it's in the air. You're not getting paid, Mr. or Miss Steel Erector, until steel is in the air. And on 324, there wasn't a whole lot of steel in the air. So they submit a pay application dated 320, which is clearly before 324, that says we're billing for joist and deck 100% and erection 10%. They are clearly not entitled to that. You haven't seen the contract, but take my word for it. They're not allowed to bill for these things until they're there. And we deposed their witness, and he literally said, yeah, we never looked at that. We never saw that. But they bill for 100% joist and deck, which they're not entitled to, and they don't get paid for it. Construction manager says, the owner's not going to pay me for that because I have a contract that says, no, I'm not going to pay you for that because you have a contract that says, no. It's not my fault you got this wrong and that you're having cash flow issues, but it became a dispute. And this contractor got badly behind because of cash flow issues and other issues. Frankly, they probably just weren't quite sophisticated enough to handle this project. They got behind and they sued the construction manager. They sued my client because they said, we had a contract and we've got pay applications and you're not paying them. The response, the contractor actually did pay them way more than they were due. They paid them 70% on the joist and deck, even though they didn't have to pay them anything. Just recognizing that cash flow was an issue and trying to help a company along and try to get contract completed, they still paid them. The point of this is understand your contract, read it carefully, and perform according to it. Even if you think you're going to be able to be paid for material when it's in your shop, maybe you're not if the contract doesn't say so. I said, again, I was a drywall contractor. One time I had a project that had flagpoles in it. Why in the world a drywall contractor would ever have to install flagpoles remains a mystery to me. But it was in there, and I missed it. And it became a real problem at the end of the day when the irrigation system around the landscaping, the sprinklers, and the electrical for the lights to illuminate the flagpole, when all that was installed and I didn't have my flagpole installed yet, I had people digging holes with shovels, and they didn't care much for me at all for quite a while after that. So just take a look at your contract. This is one of those situations where they didn't take a look at their contract and they expected a cash flow situation which wasn't real, which couldn't happen. And to get to the point about pictures and schedules, schedules are good too. Schedule is another thing that sometimes gets neglected. On this particular project, the Toyota project, same one we're looking at here, they asked for contractor input on schedule, as you should. Subcontractors should always be involved in the creation of a project schedule because as a general contractor or as an owner, you do not know, you cannot speak for your subs. So on this particular project, the sub gave their input and the contract was based on that input. And so this is a contract document that says, basically, I'm gonna have shop drawings by day X, I'm gonna have steel delivered on day Y, and I'm gonna get done on day Z. Those become contract documents. Or this wasn't even like, they didn't even incorporate, again, I said, if something is important enough to be in your schedule, in your contract, it is better to actually write it in your contract. They could have just incorporated the contract. They could have said, contract documents, schedule, exhibit A. But this was important enough to this company to go ahead and write them in. Now, if you don't meet these dates anymore, that's breach of contract. You are in breach if you don't meet them. So the contractor built a schedule based on those dates, and that's what you see here. This is just a little demonstrative, obviously, but the actual document, the actual contract schedule looked a lot like this. So we've got our milestones here. We've got our dates on the top. And what's important here, this is the structural, steel, erector, and fabricator scope of work, these 5 line items. This black dot here, or black square here, is project completion. liquidated damages and all the associated accoutrements, are involved, Toyota doesn't get its building on July 1. So per the contract, for the project schedule, which is part of the contract, this contractor is supposed to be done on April 1, which gives all the other trades, everything that comes after structural steel, concrete, finishes, mechanical, electrical, plumbing, everything that comes after structural steel has 13 weeks to get done so the project can be turned over by July 1. That's the contract schedule. Schedule updates are important because no project's perfect, no schedule's perfect, everything changes. This contractor, the general contractor, not the steel erector, but the general contractor did a good job with the schedule updates every month. January, February, March, April, May. And you can see every single month, as I'm sure most of you know on here, this red line is the data date. That's basically, for all intents and purposes, the day that the schedule was written. Everything to the left of it is in the past. Everything to the right of it is in the future. So everything to the left has already happened. Everything to the right is a prediction of what's going to happen. So you see appropriately every single month, this red line moves because it's another month. And every single month, what we thought was going to happen is taking longer and longer and longer. And steel erection is not done. We keep going. And finally, we get done with the project. And originally, this thing was supposed to be done on July 1. We've had to acknowledge that it's not going to be done on July 1. It's not going to be done until sometime mid-August. Contractors that come after the steel erector, fabricator, aren't going to have 13 weeks anymore. They're going to have 11 weeks now. And what we have at the end of the day is an as-planned versus as-built schedule. Now keep in mind, this steel fabricator erector is the plaintiff. They're the ones that filed the lawsuit. Basically what happened, and not basically, what did happen is at some point the construction manager realized you are so fouled up on this project, you are so far behind that we're not going to get done on time. We're going to get hit with liquidated damages. We have contractors who were expecting to begin work in April, and now they're not going to be able to begin work until June. And instead of having 13 weeks, they're going to have 11 weeks to get this thing done. That's going to cost us money, and we're not paying you anymore until we figure out how much is. And if there's anything left over, then I guess we'll break it off to you, but there's probably not going to be. So we're going to stop paying you for your work on this project. So they filed suit. They said, we performed, you hired us to erect steel, we erected steel, we're done, you didn't pay us, lawsuit. But we had these schedule updates that they never objected to once. They never said, your schedule's wrong, it's unfair, it's inaccurate, it's not our fault, blah, blah, blah. They just went along, and then at the end of the day, filed a lawsuit. Don't wait till the end of the day to start documenting things. And photographs, to bring this to bear, are huge because they tried to argue that the schedule updates were inaccurate, that this isn't fair, this isn't accurate, this isn't right. These pictures show that it is. And the last one really does the trick. This is June 3rd. Project's supposed to be done July 1. They were supposed to be done April 1. They don't even have all the deck on yet. There is nobody in their way. There's nobody holding this project up. There's no bad plans, no bad management. There's no other subcontractor, screwing things up. It's June 3rd. They still don't have deck on. That tells the tale right there. So pictures, pictures, pictures. Wrapping it up here, we got about 15 minutes left. I'm going to talk about some of the more important contractual clauses that you need to look at or at least need to be wary of. Again, we talked about all of the different templates that are out there. AIA is by far has the market share. Consensus, AGC, DBIA, and EJCDC are all out there too, but in my market cases I litigate, I see AIA generally, or I see some unique company built manuscript. AIA is a good document if it is moderated to be a little less owner friendly. It's a good place to start. It's got some things in it that just are a little bit contractor unfair that can be revised and dealt with, but it's better than writing your own contract from scratch. And you can do that, by the way. I always tell my clients, mechanics liens, this is a thing. And I know my man, Rick Hamilton did a mechanics lien seminar for ACI recently. Rick's a good dude. Rick's a good lawyer. And, but to echo something Rick might have said, and if he didn't say it, I'll say it for him, never draft your own mechanics lien. Never, ever, ever, ever. I'm a mechanics lien guy. That's my thing. And every single time I file one, I hold my breath a little bit because there are a million ways to screw up a mechanics lien. I literally saw a mechanics lien for about $250,000 get thrown out because the notary's line said affirmed instead of sworn and subscribed. Never do your own lien. They're scary. You can do your own contracts, however. Don't do your own contracts if you've never done one before. But if you have somebody in your company who is sophisticated, or you want to have your lawyer walk through the first 2 or 3 with you, after that, sophisticated business person can do a good contract. And the AIA is a good place to start if you've never done one before, or if you've done a few. I said there are some a little too owner-friendly clauses in there that can be dealt with. You'll know them when you see them, or if you don't, you can ask somebody. But it's a good place to start. Consensus docs is a good one too, and as are all these other ones. They've all been tested and tried and true. Private projects can be a little different. Private projects, again, or private contracts, when you've got a company that's just drafted their own thing, they can be really onerous sometimes. I've got a client right now that signed a deal on an owner contract that is ugly. I mean, it couldn't be any more mean-spirited to the contractor than it is. And it's unfortunate that it was signed that way. So take a look. If you can start with an AIA or one of the other templates, that's great. If it's a manuscript, be a little more wary when you review it. If you're not comfortable, get somebody who is comfortable involved. That's not as funny as I thought it was. Another clause is you can ask for your owners or your general contractor, if you're a sub's, financial information. You can, for most any sophisticated commercial contract, or even an unsophisticated commercial contract, you have the right to have a guarantee, to have something in evidence that shows that this company is able to pay your bills. And you can demand that. And if that's not in your contract, it should be. And if you demand it, they shouldn't be offended. It's just business. You know, we're not saving the whales here. We're building buildings. And if you have some concern, either during the negotiation phase or during the actual construction phase, that your contractor or your owner is borderline insolvent and you're worried about it, you should request proof that they can handle it. And if they get offended by it, that is a warning flag to you. If they won't provide it to you, that is a warning flag to you. There's a thing called anticipatory breach. If you have a contract clause that says, I am entitled to proof that you can keep paying me, and they refuse to give you proof, that's a breach. That is a cause for you to leave a project, if that makes sense. And to be fair, leaving a project rarely makes sense. Even if you're totally getting the shaft, if your company can withstand it, you should finish a project and fight about it later. You should mitigate your damages. But if it's just if it's a Kenwood Town Center type of situation, and you know this is going nowhere, we need to get out of here, you can ask for proof, and if they don't give it to you, it is as good of a cause as any to terminate a contract and leave a project. Pay when paid versus pay if paid. I'm not going to read all of the bullet points here. I'm just going to talk about them. These are a big one. Pay when paid versus pay if paid is a means of shifting the risk of owner non-payment from a contractor to a subcontractor, or retaining it by the contractor. I'll say it differently. If I've got a pay if paid clause, it basically says, I'll pay you if I get paid. I'm the contractor, you're the subcontractor. I'll pay you if I get paid. Pay when paid says, I'll pay you when I get paid. And those things don't seem very different if you don't know any better, if you haven't fought this battle, but they're hugely different if you have to go down this road. Pay if paid puts the burden on the general. I'm sorry, on the pay if paid puts the burden on the subcontractor. So I'll pay you if I get paid. This is going to make sense in a minute. I know I'm talking in kind of confusing words right now because it's a confusing topic, but I'll get to the point. Pay if paid says, I'm the general contractor. If I get paid, I'll pay you. Under that circumstances, per case law, take my word for it, per case law, I still have to pay you someday, no matter what happens. If it is a pay if paid clause, as a general contractor, I say I pay you if I get paid. Then even if I don't get paid, regardless of what that contract says, regardless of how clear on its face it is, this is that little mermaid thing where it looks like a black and white thing, and how can it be any way other than what it is? This is one of those cases where, you know, King Triton's magic lightning doesn't bounce off, it destroys it. Pay if paid. If I've got a pay if paid clause that says, dear subcontractor, I'll pay you if I get paid, and I never get paid, I still have to pay my subcontractor within a reasonable time, whatever that is. Of course, we'll decide 30 days, 60 days, 6 months, who knows. But eventually, that payment has to be made, regardless if I ever get paid from my owner or not. Pay when paid is the opposite. It's the yin to that yang. I never have to pay that subcontractor unless I get paid by the owner. And the magic words, and I'm basically almost literal here, is condition precedent. It's in the slide. If it doesn't say the words condition precedent, I don't care how much it looks like a condition precedent. If it doesn't say condition precedent, it's a pay if paid clause. And if I am a general contractor or a general contractor's lawyer, I'm putting condition precedent in there. I'm putting the whole clause in capital letters and in bold. Courts hate this clause. Courts will find any reason that they can to get out of a pay if paid situation. They think, hey, the contractor is higher on the food chain than the sub. They're the one that's responsible if something goes south. They're the ones at risk. And unless they are very, very deliberate about pointing that risk down, if they haven't made it abundantly clear to their subcontractors that they have pushed that risk down, then we're not going to let them push that risk down. Courts hate pay if paid clauses. So if I am representing a general contractor, I make sure, bold, capital letters, condition precedent. If I'm representing a subcontractor, I do my best to make sure none of that is in the contract, because those two words, as strange as it seems, change everything. The words condition precedent aren't in a deal. The contractor is at risk for owner non-payment. And if they are in there, then the subcontractor is at risk. So pay attention. Ohio and Kentucky have fairness acts that require contractors to pay their subs within a certain amount of time. Ohio right now, I just wrote an article that's in the winter edition of ACI's magazine, talks about how Ohio is trying to amend the statute to make it enforceable on owners too. Right now it's not. Owners can, per the law, pay whenever they want. But contractors have to pay in Ohio within 10 days of receipt of payment from an owner. They have to pay their subs within 10 days, and I think it's 30 days in Kentucky. I'm almost certain that's right. And they're trying to amend that right now to make it also bear down on owners as well. So be continued on that. I think there's like 29 other states that already have laws to that effect. AGC, the mechanical contractors, main trade group, I can't remember exactly what it's called. Everybody's weighed in on it. It's got good momentum, so hopefully that will become a thing. But you do have a right to be paid an undisputed invoice within a certain amount of time in both Ohio and Kentucky. And if you don't get paid, you may be entitled to interest. It's 12% in Kentucky and maybe 18 in Ohio, and attorney's fees if you have to sue over it. Again, nobody wants to sue, but if you have to, it's a good thing to add to your arsenal. Notice issues. Notice issues are a big deal. Again, I'm not reading off the slide here, but they're here if you need them. Well, courts are very prickly about the notice clauses in your contract. If it says if you have a legitimate change request, something's happened that's outside of your scope of work, then you must notify the owner in writing within 7 days. If you don't do that, you might have real problems. And even if it happens 100 times, you should do it 100 times. It's tedious. You're not in the business of writing letters and putting people on notice. I get that, but the courts are more prickly if you haven't gone down this road about these notice clauses than you might expect, particularly in Ohio. Kentucky is a little bit more relaxed, but not much. In Ohio, if the contract says notice in 5 days, it's notice in 5 days. Even if the owner says, stop giving me notice, I get it, do it anyway, because you'll be better off. Scheduling, just some tips. Be clear on who's responsible for what, who's in control of what. Make sure it's a contract document if you're in an owner's or general contractor's position. Delays, no damage for delay clauses. You'll see that in more contracts than not. Basically, if you don't know what they are, it says if this project winds up being delayed for no reason of your fault, Mr. Contractor, Miss Contractor, we'll give you extra time. We won't call you in breach for not being the schedule, but you don't get any more money. In Ohio, those are not enforceable. Don't care what the contract says. Little Mermaid example again. King Triton can shoot that one down with his magic trident, because even if a contract says you don't get any damages for delay in Ohio, that doesn't matter. I can make a contract, we can write it down, make it look all legal, that says I contract with you to kill that person for $10,000, and you kill that person and I don't pay you, and you sue me for breach. We're both going to jail for conspiracy to commit murder and murder. We're not going to actually win. You're not going to win your breach of contract lawsuit type of thing. That is an extreme example of trying to enforce a delay damages clause. It's I don't care what it says. It's unenforceable in Ohio. And if there's a contract that says I'm not paying you for a delay, so what? The best thing to do when you're negotiating is to strike it and to cite Ohio law. I don't sandbagging. There's just not a lot of future in it. So don't just say, well, hell, if this ever becomes a thing, we'll just deal with it then. Just say, hey, per Ohio law, this is gone. But if you've signed a contract, if you're dealing with a contract and now it's being someone's trying to invoke it on you, now you know, it's not enforceable. You are entitled to those delay damages. Liquidated damages are a thing. Basically, if you don't know, liquidated damages says I will pay you X amount of money for every day my project's late. For every day I don't perform, for every day I don't hand you a CO, certificate of occupancy, you get this much amount of money a day. They are enforceable provided they aren't a penalty. That's the magic word, penalty. If it is a penalty, it is not enforceable. So if I am building a McDonald's franchise and there is a liquidated damages clause that says $10,000 per day every day this is late, unless McDonald's franchises clear $10,000 in profit a day, that's a penalty. That is not enforceable. It has to be a reasonable approximation of the actual money lost by not having the project done. So if your average McDonald's only clears $500 profit a day, then $10,000 it's nothing more than a penalty. It's a punishment. It's punitive, and you're not allowed to do that in breach of contract. Another point about liquidated damages is once in a while, believe it or not, they're a good thing. They're not just a floor, they're also a ceiling. So if you have a project that's losing $10,000 a day because you didn't get it done on time, and your liquidated damages clause is $1,000 a day, that clause is helping you. It's limiting your liability rather than creating it. That's the most overused slide in all of construction, so I thought I'd throw it in there. Got a dinghy named original contract and a boat named change order. Talk about them. Again, for purposes of saving time, because I've about used all of mine up, just document. If you are asking for or expecting to be paid extra beyond your contract, make sure you're tracking your costs very carefully, and B, your entitlement. If somebody has told you we will pay you for this, write that down and send it to them. Indemnification is, you'll see in a lot of contracts where an owner will try to stick you with, even if we screw this up, you're not going to hold us responsible for that. There's a statute in Ohio, you can look it up. There's a reference to it right there that says you can't be contractually indemnified for your own negligence. So that's that. Sorry. And we talked about dispute resolution already. Termination, real quick, that's the end of it, is if your termination is the measure of last resort. So unless you're hemorrhaging money so bad on a project that it makes no sense to continue working on it, it's better to continue working on it. Otherwise, if it is that bad, if it is a Kenwood Town Centers type of situation, then termination really shouldn't be an option. But if your company is not able to continue, or if it's just clearly a situation where it's lose-lose, then termination might be worth considering. Otherwise, think very, very carefully about it. My wife is also a litigator, and she just stuck her head in here, obviously, and she's got a call at noon, and my time is up as well with you all. So I appreciate your conversation very much. If you need anything, there's my contact info. I'd be happy to chat with you. Otherwise, God bless. Everybody stay safe. Thank you.
Thanks, Chris. And if you guys have any questions, his contact information is on the screen, or you can send it to me. Sorry, I look really dark right now. But I can get that information to him for you guys. So have a good day. And again, this was recorded, so I'll shoot that out to everybody, hopefully this afternoon, if not tomorrow morning. So thanks, Chris.
Thanks, Jen. Good to see you.
See ya.
Yep. Bye-bye.